Good morning. Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Shortner, Saffarini, Paxton, Hughes.
Good morning. As folks realize who participate frequently, there are members of the Senate in various committees this morning presenting bills in other committees and also serving on other committees. And so we'll be moving through the agenda with participation and members of the staff, of course, are monitoring, participating here and on television. And so we'll, Senator Menendez, welcome. The chair lays out Senate Bill 801 and recognizes its author, our colleague, Senator Menendez, to explain the measure. Good morning, Senator.
Good morning, Mr. Chairman. I see Senator Zaffarini's with us as well, and I will say good morning to the Dean of the Texas Senate. Chairman Hughes, and to your staff, thank you for setting Senate Bill 801. You know, Mr. Chairman, we've talked a lot this session about the homelessness and people who are unhoused and unsheltered. And what we need to realize is this bill on its face is about accessing birth records at no cost. But what we all need to think about is, why is that important? Because without them, you can't get an ID, a state ID. You can't get a driver's license. You can't get certain services, such as housing, jobs, credit, things that you need to have a life to become a productive taxpayer. And so in order to get these forms of common ID, Texans need to submit these birth certificates and other forms to prove their identity. And so as we better aim to address homelessness in this state and make it to where you don't leave any of our neighbors living out in the streets, this bill ensures that the state and local authorities are not a barrier to the process of someone getting back on their feet and finding housing and finding a job. What the bill would do is direct Department of State Health Services and local clerks to issue upon request without a fee a birth certificate to individuals experiencing homelessness. According to the LBB, this bill will not have a fiscal impact to the state. Currently, it's about $22 for a certified copy of your birth record. It may not seem to many of us in this room like a lot of money, but as you know, Mr. Chairman, for someone who is homeless or unhoused, they're trying to pick up every coin, every dollar, sometimes relying on the kindness of strangers just to buy a meal. And I'm sure many of us have not been through a drive-through lately, but just as a refresher course, a Whataburger meal these days is about $15, almost $15. So when you're someone who's experiencing homelessness, every penny counts. If a birth record is key to obtaining a job, an apartment, this is an investment that's going to help the rest of the state as we are trying to help our neighbors that as you know, because I know you're a man of faith, that have been God made in our image and made no mistakes. Many of these kids who come out of the foster care system experience homelessness at a greater rate than others. And so the bill will also build off Senate Bill 2054 that we passed in the 87th regular session that came out of this body unanimously, which created a fund to pay for costs associated with obtaining a driver's license for youth in foster care and experiencing homelessness. In fact, what happened then after that, St. Mary's Center for Legal and Social Justice was able to coordinate with a school district to ensure that the kids had access to identifying documentation. And that is how bills like this can change lives. And you know, Chairman Hughes, I mean, we pass a lot of bills around here, but rarely do we pass things that can help change lives and improve lives. And so that's what we're trying to do. And at the end of the day, when we do the right thing, I think it helps all of our constituents. And so my only invited guest, Mr. Chairman and members, is Maria Benavides, sitting here on my left. She's the Chief Executive Officer of San Antonio Youth. She is here to share with you how imperative this bill will be to the young people experiencing homelessness. And so I know that there's a DISH's witness here as a resource to answer any questions. At this time, Mr. Chairman and members, I sit for any questions you may have.
Thank you, Senator. Members, any questions for the author? Thanks for this bill. We'll open testimony, and the chair calls Maria Benavides. Welcome, Ms. Benavides.
Thank you. Good morning.
Good morning.
As Senator mentioned, my name is Maria Benavides. I'm the president and CEO at SA Youth out of San Antonio. And one of the programs that we offer at SA Youth is the YAS Center. It is in collaboration with SAM Ministries, where we provide educational support and workforce development for 18 to 24-year-olds who are experiencing homelessness. Our SOAR program, which stands for See Our Achievements Rise, allows for students to earn an accredited high school diploma, not a GED, as well as wraparound services to include college and career readiness and connection to vital community resources. I'm here today in support of Senate Bill 801. I do not need to tell you all that unhoused young adults face a multitude of barriers. One barrier in particular addressed in this bill is the difficult process of obtaining a certified birth certificate. Not only is the cost $22, like Senator mentioned, but that $22 is completely unobtainable, where that $22 for you and I can easily be taken out of our pocket. It's not easy for this population. Requesting a birth certificate also requires a physical address where the copy can be mailed. It is barrier after barrier for these kiddos that we serve. I have personally seen clients who have missed out on housing opportunities, on employment opportunities because of the lack of a birth certificate. And it is very unfortunate. We had a young lady that we worked with for about 6 months who came to us referred by SAPD. She had been picked up at a local park where the unhoused tend to congregate. And SAPD picked her up. It just happened to be that that morning, that officer was at an outreach event where SA Youth was passing out flyers, and he gave her one. And she called us, and she asked for help. And we said, come on over. So she came to us. She had no documentation whatsoever. And in that process, we helped her get her birth certificate and her ID, which allowed her to attend a program for Ready to Work, which is a large initiative in San Antonio. And through that program, and with the help of SA Youth, she was able to get into a phlebotomy course where she graduated with a phlebotomy certificate and is now housed and working as a productive member of our community. We're very, very proud of her. And that's just one story. I could take up hours probably talking to you all about stories, but that is the student that we see. Since we've been opened, we've served about 400 unhoused 18 to 24-year-olds. And of those 400, about 200, about half of them have sought services through SA Youth, wanting help in getting their diploma and then wanting a post-graduation plan. Of those 200, we have helped 128 of them get copies of their birth certificates and their IDs. That's almost half of them who come in here looking for those services. And it wasn't easy. We had difficulty trying to navigate the system ourselves. Those funds have to come out of our limited budget. And so that's why this bill is important, among other reasons, right? Removing any barriers that we can would allow our students and countless others to include seniors and veterans. This is not just about the 18 to 24-year-olds. There are seniors and veterans who are also homeless out in our community. And it would allow them opportunity to better their lives, and in some cases could possibly even end generational cycles of homelessness. This barrier removed could bring hope to a situation and a human being. Even more important, it would bring hope to a human being who currently does not see hope in anything else. In conclusion, I would like to reiterate my support for this bill on behalf of the over 400 students we have helped at YAS, including 178 of them who sought SA Youth Services. 128 of them we helped obtain a birth certificate and ID. Many of our kids, we've graduated 70 students who went from homelessness, who are now housed and on the right pathway. Thank you all for your time and your support. Any questions?
Ms. Benavides, thank you. Thanks for what you're doing. Thanks for your testimony. Senator, any questions for Ms. Benavides? Thank you very much. Senator, you're recognized.
Thank you, Mr. Chairman. Just to wrap up, the state of Texas has thousands of homeless throughout the state. this bill would direct the Department of Health and Human Services to develop a process in order to verify their identity, the appointee of the governor's office. So we know that we're not going to do anything to allow for any type of identity theft. But folks, we've also passed bills to make public camping illegal. So what's happening in our cities, these encampments are coming in and they're being swept out with bulldozers and other equipment, and people are losing all of their documents, they're losing their life things. So through no fault of their own, many times they lose these documents that they need to have a better life. In this process, which is insignificant in terms of, to many of us, this $22, there will be a process by which dishes can help people get on their feet. And I think at the end of the day, that's what we want. We want people not to be living on the streets. We don't want people living permanently in government subsidized housing. We want them to be taxpayers and to have a life. And so hopefully this will help us in many cases. And let's not forget that the foster care system is one of the biggest provider or suppliers of homelessness or unsheltered people. So thank you for setting this bill, Mr. Chairman. It's an important bill that I think will help a lot of folks living in our state, and it will help us do something productive about the homeless issue. Thank you very much.
Thank you, Senator. And Ms. Benavides is the witness we had registered, but we'll make sure we're clear. We're opening public testimony on Senate Bill 801.
Last thing I forgot to say, it's her daughter Clara's birthday today, and it's her first time in the state capitol. So if y'all see fit to vote positively on this bill, it would be helpful. She's sitting right back here.
It's how she wanted to spend her birthday.
Oh, wow.
She's very excited to be here, and it would be a wonderful gift for her if we could get this bill passed.
Welcome, Claire, and happy birthday. We need to ask also, is there anyone else wishing to testify on, for, or against Senate Bill 801? I'm going to make sure no one's left out. Thank you for your testimony. Thank you for the bill, Senator.
Thank you.
Thank you for being here. And public testimony is closed on Senate Bill 801, and bills left pending at this time. The chair now lays out Senate Bill 1410 by Senator Campbell. Senate Bill 1410 recognizes our colleague, Vice Chair Paxton, on behalf of Senator Campbell.
Thank you, Mr. Chairman. Thank you, members. Senate Bill 1410 simply requires all Texas state agencies to rename Gulf of Mexico with Gulf of America in official documents, policies, and regulations. This aligns state documents with federal directives. Agencies must prioritize renaming in emergency management, commercial operations, public health, and other critical areas. With that, members, thank you.
Thank you, Senator. Members, any questions for the Vice Chair on behalf of the author? Very well. Before we open testimony, that bill is before us, and the Chair now lays out Senate Bill 1717 and recognizes its author, our colleague, Senator Middleton, to explain the measure. Senator.
Thank you, Mr. Chairman. Members, on January 20th, President Trump issued Executive Order 14172, which renamed geographic places around our country to honor American exceptionalism. And part of that was renaming the Gulf of Mexico as the Gulf of America. The President's executive order directed the Secretary of Interior to rename the Gulf within all federal documents from maps to contracts to reflect this change. And that has already occurred with the Federal Geographic Names Information System. So that is the official federal procedure to do that. And that has already happened. And this is a America First bill. And with that, I yield for questions. Thank you.
Thank you, Senator. Any questions for the author? Very well. While that bill is also before us, the chair now lays out Senate Joint Resolution 63, SJR 63, and recognizes its author, Senator Middleton, to explain the measure.
Thank you, Mr. President, or sorry, Chairman, members, Monday morning.
I understand that.
More coffee. So the Gulf of Mexico is referenced several times in our Constitution, and so this is a joint resolution that conforms it with this legislation in SB 1717 to rename it Gulf of America in our Constitution.
Thank you, Senator. Members, any questions for the author on SJR 63? Very well. Before the committee now are Senate Bill 1410, Senate Bill 1717, and Senate Joint Resolution 63. We will open up public testimony on all three of those measures. And some witnesses are here on some and not the others, so we'll just sort that out as we go. They're related content. And so we'll begin with invited testimony. Chair calls Honorable Chuck DeVore.
Thank you, Mr. Chairman. Members, my name is Chuck DeVore. I'm with the Texas Public Policy Foundation here to testify in support of SB 1717 and SJR 63. Mr. Chairman and members, when looking at the feature, the geographic feature known as now as the Gulf of America, I think it's important to understand a few basic issues. Number one, if you look at the current exclusive economic zone that covers the Gulf, only 3 nations have any sort of economic claim. That would be the United States, Mexico, and Cuba. No one nation has an absolute majority of the EEZ in the renamed Gulf of America. Number two, if you look at trade that transits the Gulf, the overwhelming share of trade that plies the waters known now as the Gulf of America is trade going to and from the United States. Number three, it's not uncommon around the world to see different nations applying different names to geographic features. For example, in the South Atlantic, the feature known in the English-speaking world as the Falkland Islands is known in the Spanish-speaking world as Islas Las Malvinas. Similarly, near the waters of the People's Republic of China and Japan, you have a feature, rock outcropping that is known as the Senkeikus in Japanese and the Daewoo Islands in Chinese. So this is not a particularly rare thing around the world, and for that reason, I think for purposes of clarity and to align Texas statute with the federal edict, we are in support of these measures. Thank you, Mr. Chairman.
And thanks for your testimony, Senator. Is there any questions for Assemblyman DeVore? Thanks for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 1410? Seeing, hearing none, public testimony is closed. Senate Bill 1410 is left pending. Is there anyone else wishing to testify on, for, or against Senate Bill 1717? Seeing and hearing none, public testimony is closed, and Senate Bill 1717 be left pending at this time. Is there anyone else wishing to testify on, for, or against Senate Joint Resolution 63, SJR 63? Seeing and hearing none, public testimony is closed. Bill is left pending at this time. The chair now lays out Senate Bill 1200 and recognizes its author, our colleague, Senator Colcourse, to explain the measure. Welcome, Senator.
Thank you, Mr. Chairman. Good Monday morning to everyone. Good to be back and working. Mr. Chairman and members, I'd like to lay out before you Senate Bill 1200. Now, it's an even number. I never get those numbers. It was accidental, but I'm super excited about it because it's one of my favorite bills of the session. During our work in this committee, I've laid out some pretty interesting bills. Senate Bill 147, which is now Senate Bill 17. Senate Bill 1040 came through my committee, which was an organ harvesting ban. But we have learned about a lot of different ways that adversarial nations can infiltrate our state and in what they engage in. In recent years, it's become a mounting concern. America's enemies are funneling money through proxy enemy entities to diminish economic development, energy production, and manufacturing by the United States, in essence, sometimes to weaken us. Specifically, there is concern that our nation's adversaries are funding third-party entities in their lawsuits against defense contractors. This weaponization of our U.S. judicial system and even bureaucracy in some cases through frivolous lawsuits is resulting in expensive and drawn-out lawsuits. These lawsuits divert money away from vital research and development in the defense industry, and more importantly, impact our overarching national security by jeopardizing defense sector objectives. I learned about this in the interim and became very interested in it, members. And so in filing SB 1200, very simply, this bill requires those suing defense contractors to disclose their ties to adversarial nations if asked during discovery. SB 1200 amends the Civil Practice and Remedies Code to require plaintiffs to disclose if they are receiving funds from the ITAR sanctioned countries such as China, Russia, or Cuba to defense contractors in the state of Texas. This bill does not stop lawsuits. It simply demands transparency in civil action. We should know if Cuba is defending a lawsuit against a defense contractor here in our state. We have a lot of defense contractors throughout this state. So SB 1200 will thwart the desires of adversarial nations, which are millions of dollars wrapped up in legal battles, delaying these critical projects. If a foreign adversary is not funding these lawsuits, SB 1200 will do no harm to those bringing legitimate lawsuits on environmental and other legal concerns. Simply put, let's support our defense contractors and keep our nation strong and secure by exposing some of these disingenuous civil actions that might be funded by our adversarial nations. And so, of course, y'all might know what ITAR is. It's the International Traffic in Arms Regulations. It ties it to that particular part of the federal law.
Thank you, Senator. And do you have a committee substitute on this one?
I do.
So Senator Zafrani sends up the committee substitute and recognize Senator Colcourse to explain the substitute.
The changes in the committee substitute, it makes it applicable, the applicability of the chapter now extends to actions regarding activities of the United States defense contractors, not just against them. Sometimes state agencies such as TCEQ currently and other entities are the subject of lawsuits pertaining to the activities of a defense contractor. We would like for this bill to apply to those cases as well as cases against defense contractors. That would be in the substitute, page 1, lines 8, and 9. Again, it doesn't stop the lawsuit. It just says in discovery, you have to say, who's funding this lawsuit? The definition of defense contractor is also adjusted to limit applicability to only those entities that are making goods or selling services to the Department of Defense that are controlled under the ITAR. So the company that provides coffee or administrative services would not be considered a defense contractor. So we narrow the definition of defense contractor. Although, we know that coffee is very important. I've always been a fan of coffee, used to own a coffee company myself. That is not what we're looking at. We are truly looking at that definition of our defense contractors being those that are those building our weapons and doing major research to defend our citizens of the United States and defend the Constitution of the United States.
And thank you, Senator. Members, any questions for the author on the committee subject? Senator Paxton, you're recognized.
Thank you, Mr. Chairman. Good morning.
Good morning.
So you define defense contractor in the bill, and I'm sure you do this as well, but just for the benefit of those listening, how is adversarial nation defined?
Yeah, it's tied to the International Traffic in Arms Regulations, which is defined, I have several sheets on it, I'll be happy to provide it to you, but the International Traffic in Arms Regulations is a set of U.S. government regulations that control the import and export of defense contracts, and so they list out those that we don't do business with.
And just to be clear, this is tied to a specific list.
Yes.
That is defined by our federal government.
Yes.
Thank you. I appreciate that.
Thank you, Senator Paxton. Members, any other questions for the author? Very well, thank you for the layout. We'll open testimony and we'll hear from the witnesses.
Thank you, Mr. Chairman. I am currently in water, agriculture, and rural affairs. And so there's a lot of storm in there right now. Senator Dean Zaffarini laid out 2 bills. I'm going to stay for a few moments, but I may have to go back to vote.
Of course.
Thank you.
Of course. Thank you. We always remind folks watching that senators are on multiple committees and have bills in multiple committees, so thank you for that. And our staffs are paying attention and tracking everything as we go. Thank you, Senator. We'll open public testimony on Senate Bill 1200, and the chair calls Kevin Reddington. Mr. Reddington is the only witness at this point that has expressed a desire to testify on, for, or against. If anyone else wishes to, please make your way down to the table. And welcome, introduce yourself, get situated, and give us your testimony.
Thank you, Mr. Chairman. Good morning, members of the committee. My name is Kevin Reddington. I'm the assistant. Oh, sorry. I'll start over here. Good morning, Chairman Hughes, members of the committee. My name is Kevin Reddington. I'm the assistant general counsel for Texans for Lawsuit Reform, and I'm here in support of this bill. Fundamentally, as Senator Kolkhorst laid out, this is about something called third-party litigation funding. This is something that we've been concerned about for some time. And the reason is it allows an outside party to fund a legal dispute and thereby exercise undue influence and control the strategy and even the outcome of that litigation. This isn't a new problem. The great legal scholar William Blackstone called this an offense to public justice as it keeps alive strife and contention and perverts the remedial process of law into an engine of oppression. Now, SB 1200 is going after the worst possible species of this abuse, which is if an adversarial nation is going after our defense contractors, which are providing critical services and industries for the defense of this nation. This isn't merely a hypothetical problem either. As recently as last year, Bloomberg reported that a Russian oligarch was using TPLF to avoid sanctions that were imposed because of the Ukraine war. So that just shows the lack of transparency that's in this area and the issue that it's raising. In 2022, 14 attorneys general joined in a letter to then Attorney Merrick Garland warning that, quote, foreign adversaries leveraging our judicial system in order to undermine our nation's interest is a grave concern to our states. Through strategic lending, foreign adversaries could threaten our economic and national security by weaponizing the U.S. judicial system. For instance, foreign countries like China or Russia could use TPLF to fuel targeted lawsuits and weaken our infrastructure. So this is not a situation that's unique to Texas. Nationwide, Congress and the Department of Justice have been very concerned about this issue in recent years. The solution SB 1200 presents is very simple: disclosure. What disclosure does is it allows the courts and parties to know the identity of the litigation funder and help determine whether or not there's undue influence, ethical problems, conflicts of interest, etc. So we should not allow foreign countries to influence the fundamentally fair system that we have that affords litigants a right to be heard. We should not allow foreign countries to exploit that. So we ask for your support in SB 1200.
Thank you for your testimony. Members, any questions for Mr. Reddington? Thanks for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 1200? Seeing and hearing none, public testimony is closed. Bill is left pending at this time. The chair now lays out Senate Bill 2626 and recognizes our Vice Chair, Senator Paxton, on behalf of the author, Senator Campbell. Senator.
Thank you, Mr. Chairman. Senate Bill 2626 requires the Texas Medical Board and the Texas Board of Nursing to create a continuing medical education curriculum for pregnancy-related emergencies. This bill will require physicians and nurses specializing in obstetrics or gynecology to take 1 hour of the CME within 1 year after passage of this bill and once every 3 years thereafter. Thank you, Mr. Chairman. Thank you, members.
Thank you, Senator Paxton. Senator Hall, you're recognized.
I just say I think this is a very good bill, and in light of the fact we've now spent the last 2 years why doctors are using the excuse of not understanding what we passed into law as a reason for refusing to do emergency or abortions where the mother's life is in danger or where she's in danger of being damaged permanently. These are the doctors who want to overturn the law and have pretended like they couldn't do it. I think this is an excellent way to show them that they have been misinterpreting their role as a doctor and that these problems. And we heard testimony when you had your bill up from a number of ladies that had suffered at the hands of the doctors in there. And I think every one of those you testified before was medical malpractice. I think every one of those, if Texas Medical Board was doing its job, it would have gone after each one of those doctors that refused to treat those women when they needed to be treated and using them as a battering ram for trying to get the abortion law overturned. And I think what we heard from them, from the doctors who did that, was absolutely despicable. And it's a shame that Texas Medical Board can't find something like that that's very important and spend their time protecting people as opposed to harassing them.
Thank you, Senator Hall.
Thank you, Senator Hall. This is a huge issue, and thank you. Senator, is any other questions for the author or for Senator Paxton on behalf of the author on this bill? Very well, we'll open testimony. And the chair calls John Seago, Megan Benton, Samantha Furness, Ashley Lennertz, Jace Yarbrough, and Joe Poyman. welcome to each of you. We normally go from my left to right, so we'll start here and introduce yourself, give us your testimony.
All right. Good morning, Mr. Chairman and committee. My name is Samantha Furness, and I am representing Texas Right to Life and myself in favor of Senate Bill 2626. Since Texas began protecting all preborn children from abortion, we have seen some confusion crop up among medical professionals regarding what exactly is prohibited by the law. This is not due to any shortcoming in the law actually prohibiting critical care to pregnant women. Our law is designed to save all lives involved, and by no means does our law require a physician to deny life-saving care to a mother or to prevent any serious injury, even if that treatment tragically results in the child passing away. This confusion has come from widespread media reports causing fear and confusion even when they know that that's not the case. It's also come just from simple differences in definitions where the law defines abortion as the intentional and intentionally ending the life of a preborn child and excluding from that definition ectopic pregnancies and treatment of a miscarriage. Excuse me. But that's not necessarily how it's defined medically. So if a lawyer or if a doctor is just reading the law on its face, they might not realize that definition is different, how they would define it versus how the law defines it. So a physician with a basic familiarity with the law might be aware of the heartbeat law, but not of this disparity, and might see, oh, I can't cause an abortion if I can detect a heartbeat, even if that treatment is necessary to save the life of a mother, and that treatment is authorized by law. They just might not have that deep familiarity. So the purpose of this bill is just to iron out those just misconceptions that physicians and nurses might have regarding this life-saving law, and provide them the confidence that they deserve in order to save as many lives as possible. Thank you.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Thank you, Chairman, members of the committee. My name is Megan Benton. I'm the Strategic Policy Associate for Texas Values Action, and I'm here today to testify in favor of Senate Bill 2626. Texas Values Action is the largest Christian nonprofit law and policy organization in Texas dedicated to faith, family, and freedom. Thank you for taking the time to hear this bill. It's extremely important that medical professionals have quality education when dealing with pregnancy complications, including ectopic pregnancy. This bill helps to establish clear requirements for the further education of practicing nurses and doctors who work with women during their pregnancies. Not only will this bring peace of mind to healthcare professionals in this situation, but it will also help to ensure that women receive high-quality care when it matters the most. Anytime a pregnant mother finds out there's a serious complication with her pregnancy, it's difficult for everyone involved, but this bill helps to protect these women by ensuring medical professionals are properly informed about the law. Not only that, but it also ensures that the medical professionals are trained in communicating with the patient on these crucial matters. While no expecting mother wishes to find themselves in this position, it would be much more difficult if the medical professionals involved lacked the confidence to effectively communicate the condition to the mother. SB 2626 is a compassionate bill that helps to protect women and preborn babies in difficult situations while simultaneously providing educational support to the doctors involved. Please support SB 2626 to ensure that doctors and nurses involved in these situations have the skills necessary to properly handle these difficult times. Thank you.
And thanks for your testimony. Members, any questions for either of our witnesses on Senate Bill 2626? We thank you both for being here. Thanks for your testimony. Is there anyone else wishing to testify on, for, or against Senate Bill 2626? Recognizing that there's a hearing going on in the House on related subject matter, so some of the witnesses who have registered their position and wishing to testify that didn't make it will still show their position in the record, just not testifying. And with that, if there's no one else on 2626, we'll close public testimony. Bill's left pending at this time. Thanks, Senator Paxton. The chair now lays out Senate Bill 506 by Senator Betancourt and recognizes our colleague, Senator Hall, to explain the measure on behalf of the author. Senator.
Thank you, Mr. Chairman. Members, the genesis for SB 506 came after numerous voters and municipalities encountered problems when facing various ballot initiatives and charter challenges from 2017 through 2021. The highlights of SB 506 are set in statute the standard for language used on ballots, providing for easier public interaction and understanding of ballot language, allowing more citizen participation during the petition drive and simplifying the petition process, creating a non-judicial avenue for citizens to use before being required to file a judicial challenge, and when judicial remedies are required, allowing for a rocket docket in state district courts for expedited review upon filing of a mandamus petition, and allowing a court to rewrite ballot language if the court deems the language inaccurate. Ending the persecution of quid pro quo between municipalities and law firms, provides for a bad actor provision for municipalities that are unable to meet the statutorily set ballot language, and end the statutory prohibition against religious institutions from assisting with the circulation of petitions. And with that, Mr. Chairman.
Thank you, Senator Hall. Any questions on Senate Bill 506? Very well, we'll open testimony and open public testimony, and Chair calls Ed Johnson for Senate Bill 506. Mr. Johnson is the only witness who is registered on, for, or against Senate Bill 506. So if anyone else wishes to testify on, for, or against Senate Bill 506, please make your way down to the table so that we can hear from you. Ms. Johnson, welcome back. Introduce yourself. Go ahead.
Ed Johnson, also here with the Harris County Ballot Security Committee. You know, this has always been a problem in unfortunately, our large city of Houston, where they tend to, mess up the languages sometimes on the ballot propositions. This would help give a tool for clarifying that, which is real important for not confusing the voters. The double negatives and all the other stuff that go on when they sometimes put a ballot proposition up, gets to be very confusing for the voters. And that's the intent of this bill, is to try to make it to where the voters understand what is written there, clear and obvious.
Thank you, Mr. Johnson. Senators, any questions for Mr. Johnson on this bill? Senator Hall, you're recognized.
While I agree that this is a good bill, there are probably some other things we ought to look at, particularly in bonding. When they're put on the ballot, such as the true intended purpose of the bond, and
right,
that it can only be used for what the voters vote for that money to be used for. Would you agree that that would be a reasonable and good thing to also do?
That would be a lovely thing to do. Last time I checked, the rainy day fund hadn't stopped the rain at all in Harris County. So, yes.
It's not unique to Harris County, I can assure you of that. Well, Harris County may lead a lot of stuff.
Not that wasn't Harris County, that was Houston. The rainy day fund hadn't stopped the rain in Houston yet, so.
Okay. No, thank you.
Thanks, Senator Hall. Any other questions for Mr. Johnson? Thanks for being here.
Thank
You're
you.
excused. Anyone else wishing to testify on, for, or against Senate Bill 506? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 2681 by Senator Betancourt and recognizes our colleague, Senator Hall, to explain the measure on his behalf. Senator.
Thank you, Mr. Chairman and members. Concerns have been raised about how counties are managing challenges to voter registration. Under current statute, the fact must be from personal knowledge of the voter desiring to challenge the registration of another voter. However, certain counties have been taking a very narrow definition of personal knowledge and wholesale rejecting legitimate challenges to voter registration. SB 2681 amends the election code to allow for someone to challenge a voter's registration based on a fact not subject to reasonable dispute because the fact is known or can be determined from a reliable source. An example of what would be a reasonable source under this statute would be the national change of address data or death records. Thank you, Mr. Chairman.
Thank you, Senator Hall. Members, any questions for Senator Hall on SB 2681? Very well, we'll open public testimony on Senate Bill 2681, and the chair calls Veronica Warms. Veronica is the only witness we have registered to testify on, for, or against Senate Bill 2681. There she comes. Ed, come on down. We'll make sure. No problem. And if anyone else wishes to testify on, for, or against Senate Bill 2681, please make your way down to the table this time. Hold tight just a second. Ms. Johnson, we'll just get a card from you on this one just to make sure everything's tightened up. We know you're in the system on various bills, but promise me you'll fill out that card before you leave.
I will.
And you are recognized. Welcome.
Okay, thank you. Ed Johnson with the Harris County Ballot Security. This is very important. I actually have been on many statewide, Zoom calls and things like this, and this is not just a Harris County problem. They're going on all over the state where they're really questioning the definition of personal knowledge, and that this language helps define it a little more. I'll give you an example of where this has gone wrong. In Harris County, it's been 3 years ago now, took the national change of address list, found several thousand people that had moved, and then actually had a team of volunteers that went out and walked these houses, went by and actually saw them and visited to make sure, confirm the national voter registration, national change of address list information was correct. They presented it to the voter registrar in Harris County, and they claimed that that group did not have personal knowledge and would not accept those, to send them a confirmation notice to help clean up and make those people registered where they really live. And really probably disenfranchise those people, because when they move to a new county and they go to vote, well, they're not registered there, so they don't get to vote. They have to vote a limited ballot and come back to Harris County if they can make it to do that. So it's tough, and this helps clean up the voter roll and adds a little more definition to it to make it clear that, what that personal knowledge is, that it can be a record that's not undisputable there.
Thank you, Mr. Johnson. Ms. Warms, welcome. Introduce yourself. Go ahead.
My name is Veronica Warms, and I'm representing the Texas Civil Rights Project against SB 2681. SB 2681 adds in an unworkable, vague standard into the voter registration challenge process by allowing a person to submit an affidavit based on a claim that a fact not subject to reasonable dispute because it's generally known or can be determined from a reliable source indicates that some aspect of a voter's eligibility is in question. Adding this provision into the code would allow anyone to challenge a Texan's voter registration based on facts they think are generally known or based on a source they consider reliable, but not based on anything that they actually know to be true. The standard is ambiguous, subjective, and ripe for abuse. The bill analysis suggests that national change of address data maintained by USPS would satisfy this standard, but such information suffers from the same deficiency, that SB 2681 permits the submitter of such data to simply swear to its reliability without any actual proof. For example, in 2021, an individual in Georgia challenged more than 4,000 voters' registrations in Muskogee County based on what he claimed was NCOA data. This included a 69-year-old veteran who had lived in Georgia for the past 50 years, but submitted a change of address to have his mail forwarded to a California address temporarily for work purposes. The county sustained most of the challenges until a federal district court found that such actions likely violated both federal law and the U.S. Constitution, in part because the individual providing the NCOA data had supplied no evidence that it was either authentic or recent. As this case demonstrates, allowing third parties to challenge voter registrations based on their subjective belief that NCOA data is accurate will open the floodgates to disenfranchisement in Texas. As a practical matter, though, how is a county supposed to weigh what challenges are based on information from a generally known fact or reliable source? This bill does not require the affidavit to actually name what source the author is using, nor are there any guardrails on what can be used as a reliable source or generally known fact in the bill language. Inherently, this is going to lead to different approaches and standards for voter registration challenges between counties, and it will result in voters losing their registration rights based on erroneous information. We ask that you advance proposals that will allow for timely and secure updates to the voter rolls, such as online voter registration, instead of allowing bad actors to deprive eligible Texans of their rights based on a subjective and unworkable standard. So please do not vote this bill favorably. Thank you.
And thank you for your testimony. Senators, any questions for either of our witnesses? Mr. Johnson.
Yeah, one comment that I left out. You got to remember that when you're challenging someone's voter registration, you're just confirming their address. It does not take away their right to vote. They would just go on suspense and fill out a statement of residence when they're going to vote, but they are still a registered voter.
Ms. Warnes?
If I may, that is only if the person actually responds within the 30 days after the notice is sent out. So given how people actually check their snail mail and how often people actually are able to respond in a timely manner to those challenges, it still ends up with disenfranchisement a lot of the time.
And let me ask too, Ms. Worms, is the standard in this bill, I believe the language is the same standard that's used for judicial notice.
Yes.
That was the intent. Is that right? Is that?
From what I saw, it does mirror language in the federal rules for judicial notice, but that is for a judicial proceeding, as opposed to submitting a fact in evidence that is literally the only fact in dispute, right? When you're asking a court to take judicial notice of something, it's generally a fact that the parties either agree on and don't want to spend the court's time litigating. This is literally submitting, based on a judicial notice standard, the only question that is being contested, right, which is whether a voter is eligible.
No, I think so. I see what you mean. Does using the standard for judicial notice provide some protection? Because if it's not something that's not in dispute, it wouldn't be able to meet this standard. I'm not arguing. I really want to understand your position.
I would say that that is not enough protection, unfortunately, in this case, since courts usually have precedent and what have you to determine whether something is judicially noticeable. In this case, you're asking private people, third parties who don't necessarily have any precedents to establish whether that is a reliable source, whether it's a generally known fact or what have you. You're just essentially opening the floodgates for anybody to submit a challenge based on any information that they think meets the standard. So I don't think it really provides enough protection, unfortunately.
Well, thanks for your testimony.
Sure.
Members, any other questions for Ms. Warren, Mr. Johnson? Thank you both for being here.
Yeah.
Is there anyone else wishing to testify on, for, or against Senate Bill 2681? Welcome back. Have a seat, and if we don't have you on this one, we'll get a card from you, if that's okay, Mr. Moore.
I'll have to fill out a card later.
Okay, very good. If you promise to fill out a card, go ahead, introduce yourself, give us your testimony, Mr. Moore.
My name is Ken Moore. I am for this bill, and I'm representing myself. One of the hats I wear is that I chair the Ballot Integrity Committee for the Missouri County Republican Party. And we have a subcommittee that deals with voter roll cleanup. And we've had major issues with trying to get a definition of what personal knowledge means. Talking to other people around the state who are involved in this, typically it goes to the county attorney or whoever's running the show, the DA, whatever. And the definitions they come up with are, well, many and varied. In our case, they're telling us that we need to go talk to a family member if a person's moved or if they've died. And a lot of times that's just not practical. And so this helps quite a bit in defining something is other than just, well, it limits it. And that's something that's very much needed for voter roll cleanup.
And thank you for your testimony. Members, any questions for Mr. Moore? Thanks for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 2681? Making sure, seeing and hearing none, public testimony is closed. bills left pending at this time.
The chair lays out Senate Bill 1862 by Chairman Hughes and recognizes the author to explain the bill.
Thank you, Madam Chair. Thank you, members. Senate Bill 1862 involves folks who move. When you move to Texas and apply for a driver license, you can be registered to vote. But the state that new Texan left might not get any notice to remove the voter from their rolls in the state from which the person moved. Senate Bill 1862 requires the new voter to provide their previous address to the voter registrar so that the previous jurisdiction can be notified. And then it makes sure that enough information is transmitted from the former jurisdiction to ensure that the voter can be removed from the prior voter roll. Now, to be clear, this will not affect Texans at all, but since a large number of people move to Texas every year, this bill will help other states keep their voter rolls clean. We hope other states will follow suit and share this information directly between each state's voter registration authorities. And Madam Chair, there's a committee substitute.
Chair sends up the committee substitute and recognizes Senator Hughes to explain the substitute.
Thank you, Madam Chair. The committee substitute will require the voter registrar to provide monthly reports to the Secretary of State, who will aggregate those reports and send notice to the prior jurisdictions, again, from which the new Texan moved. That's what the bill does, and yield for questions.
Thank you, Mr. Chairman. Members, any questions for the author? All right. If not, the chair will open public testimony and calls Ed Johnson.
Oh, excuse me. Ed Johnson with the Harris County Ballot Security, and definitely for this bill. This is a good one, I'll tell you. Starting to show my age now. Back when I used to work for tax collector assessor Paul Betancourt, this was the standard practice before Help America Vote. The voter registration application used to have a place for your former address. When you received those, you would contact, if they had moved from another county or another state, you would actually send a notice to that county or to that state so that they would know to clean up their voter roll. Then Help America Vote came along, and we made a statewide voter registration database, and this practice was stopped because all the voter registrations within the state were communicating, but left out other states. There's the problem, and this bill fills that hole. So this is actually something that was in practice for years in voter registration, and we should put it back, to where if they're from another state, you would send them a notice, and that way they could clean up that voter roll in that state.
Thank you, Mr. Johnson. Appreciate you being here. Dean Zaffarini, you are recognized.
Thank you, Madam Chair. Mr. Johnson, is this something we should do within the state, too?
Well, so the statewide voter roll actually does it within the state. So now that you have your VUID number, your state ID number on your deal, they track it when you move around the state from county to county, and they let the other counties automatically know. So
how well is that working?
It works really well. No, it does. It's almost a real time, within a 24-hour update to the other counties that it does. And the team, actually, if it's a hard match, we'll just remove them from that county and move them to the next.
Well, good. Thank you. Thank you, Madam Chair.
Thank you, Dean. Appreciate your question. Members, any other questions for our witness? All right. Thank you for being here.
Thank you.
Appreciate it. All right. Is there anyone else wishing to testify on, for, or against committee substitute to Senate Bill 1862? Hearing, seeing none, the bill, public testimony is closed and the bill will be left pending. The chair lays out Senate Bill 1863 and recognizes the bill's author, Chairman Hughes, to explain the bill.
Thank you, Madam Chair, and thank you, members. Senate Bill 1863 will strengthen our audits. Texas law requires the Secretary of State's office to randomly select and audit 4 counties after the November general election. Texas really pioneered these procedural audits, which evaluate the elections held in those counties over the preceding 2 years. Unlike other types of post-election audits, these procedural audits are a unique tool to make sure that to the public that elections are run according to Texas law and regulations. Procedural audits have identified substantial problems, allowing officials and counties to correct them. The audits have also showcased best practices as an example for other counties. Among other things, the audit of the 2020 general election exposed massive failures in one county's ability to demonstrate chain of custody for over 180,000 voted ballots. Ballots by mail that appeared to have been counted but were still sealed in their carrier envelopes, and data inconsistencies across multiple platforms. Those problems were all uncovered as a result of our 2020 general election procedural audit. The audit of the 2022 general election revealed issues in the counties such as inadequate training for election judges and poll workers, discrepancies between county and statewide data on ballots by mail, a lack of election-specific security planning, and repeated deficiencies in providing necessary equipment and ballot supplies. These problems would not have otherwise been detected without a procedural audit, which helps illustrate the need for and the importance of this particular type of audit, which again, Texas has pioneered. Senate Bill 1863 will expand the number of counties subject to the audit and prescribe specific areas to be audited. The bill also gives the audited party an opportunity to address findings made after an audit, requires offices to cooperate with auditors, and provides an enforcement mechanism if an audited party fails to comply. The Secretary of State will also be required to produce a public report of the audit's findings. We believe Senate Bill 1863 will clarify that political subdivisions and localities that administer their own audits are also, that administer their own processes are likewise subject to audit. And so this makes sense. It's about transparency, making sure the system is working well. Let's expand on what we're doing right and continue to improve the accuracy and confidence of our elections. And I yield.
Thank you, Mr. Chairman. Members, any questions for the author? All right. If not, then we will move on to public testimony. Chair opens public testimony and calls Veronica Worms, Ken Moore, and Ed Johnson. Senate Bill 1863. All right. Well, thank y'all for being here. And Ms. Worms, if you'll go in and kick us off and state your name and give us your testimony, please.
Of course, thank you, Madam Vice Chair. My name is Veronica Worms, representing the Texas Civil Rights Project against 1863. We oppose this legislation for 2 principal reasons. First, because we already have an audit process to make sure that county elections are being conducted appropriately, and expanding this program after such a short period is gratuitous and a waste of taxpayer funds. SB 1863 has a $4.2 million fiscal note, which could be used to better fund county elections departments and invest in voter education. Instead, it will cause already overburdened counties to have to comply with these audits on a more regular basis, which, as the fiscal note mentions, could and presumably would lead to significant county costs. Is the state going to reimburse counties for that responsibility, or is this going to be another unfunded mandate? Second, we oppose 1863 because it it allows unelected state appointee, the Secretary of State, to withhold funds from a county that does not comply with the requested production of materials during the audit process. It essentially allows the Secretary to hold county funding hostage for not producing requested materials if the Secretary thinks the county did so knowingly or willfully. This standard not only misplaces the authority that should be reserved for the judiciary, i.e. whether the county willfully or knowingly did not produce the requested information, but it's also counterproductive to the supposed purpose of the bill. Depriving a county of reimbursement funding for election expenses because of noncompliance would predictably result in the county being unable to meet its burdens and duties to voters under the election code. If the purpose of the legislation is to ensure that counties are complying with their duties under the law, hamstringing county elections departments through defunding seems like sabotage. A county that was found wanting for not processing voter list maintenance timely, for instance, would be even more hard-pressed to comply if they were unable to hire and maintain the staff necessary to get that done. For these reasons, we ask you not to report SB 1863 favorably. Thank you.
Thank you for your testimony. Mr. Johnson, if you'll state your name for the record and give us your testimony, please.
Ed Johnson. I'm also here with the Harris County Ballot Security. So I spent 10 years working in the county clerk's office, director there, running the elections. And if these audits actually are very good guidelines for the county, these are things that they should be doing. When I was there in the election office, we made sure that we had an auditable trail on all of the ballot by mails, the early in voting in person, the memory cards, the election day results and those machines, down to where the machines were, who had the cards, where they were sealed. It was a complete audit trail, and we were checking ourselves as we went through the election to make sure that we didn't miss anything, that we didn't leave envelopes, stuck away here that we didn't open, our count's off, where are those envelopes at, type things. And things like that happen, but if you have a good internal audit yourself, you will find these problems and be easily corrected. If you're keeping an audit on yourself and running a good, fair election, this shouldn't cost you any money to have the Secretary of State come and check your work. I mean, you should be able, here it is, and you hand them the books and they look through it and say, great, did a good job. So it's the counties that are not doing a good job that it would take time for them to try to recreate this. So hopefully this would incentivize them to audit themselves as the process is going along. So, and these audits are becoming very important now externally to look into the database, because with the secret ballot secrecy problem, we are, I guess, we're having to restrict the information the public can get, where public used to be able to kind of audit some of these things where you no longer have those capabilities. So it's going to be very, very important that we have the Secretary of State checking to make sure that everything is done correctly and above board.
Thank you. Thanks for your testimony. Mr. Moore, would you state your name for the record and give us your testimony, please?
My name is Ken Moore, representing myself. I am for this bill. I cannot do a better job than Ed just did explaining why I would be for this. It does a number of things that I think are very much needed. What I would like to see added to the bill, and it may be too late at this point, is I'd like to see audits for the electronic poll books. Unlike the other machines by law cannot be connected to the internet. The poll books, by their very nature, must be connected to the internet. And these are the machines that tell the clerks who is and is not eligible to vote. I have seen these things lose connection to the internet for several hours at a time, and the reason I noticed it because I'm the only one looking for it. I've seen, I have one person in my committee that election judge. He said he couldn't get his Wi-Fi to work, and so they told him to connect to the public Wi-Fi, which is not against the law, but it does raise serious issues about safety. I saw in one case an early voting voter, someone who voted during early voting period, who told us they had voted, and we found their they're reactivated for Election Day. So they could have voted twice if they wanted to and got away with it. If you're going to have countywide voting, you have to have electronic poll books. That keeps people from being able to go from one place to the other and voting twice. If you're going to have these machines, you need to ensure that they actually work. And we already have a tool in the code, Texas Election Code 31.014C, which specifies they must update in real time. And the Secretary of State has the authority to use that to assess a fee or even to take them away if necessary. I would like to see that added to the bill.
Thank you. Members, any questions for our witnesses? All right. Thank you very much. Appreciate y'all being here today. Is there anyone else wishing to testify on, for, or against Senate Bill 1863? Hearing, seeing none, the bill, public testimony is now closed, and the bill will be left pending.
Thank you, Madam Chair. And if I may say, Mr. Moore raised an important point, and Senator Parker's Senate Bill 827 addresses that, and it does, because he's right. That equipment needs to be looked at, and Senator Parker's 827 does address that concern. It's not in this bill, but it's in his that we did pass. But please, we're thankful for everybody flagging those things. Thank you, Madam Chair, for the indulgence.
16. The chair lays out Senate Bill 2216 and recognizes the bill's author, Chairman Hughes, to explain the bill.
Thank you, Madam Chair. Thank you, members. Election equipment. Folks are always, all of us are interested in making sure that the equipment is working as it should, it is secure. And I want to clarify, Texas thankfully has moved away from those direct recording electronic voting machines where you vote on an electronic console and that captures your vote and there's no paper record. We've moved away from those, and for my part, good riddance to those machines. We've moved away from those. We do not now fund and reimburse for systems like that where the votes are recorded electronically and go into some black box. Our system now is based on a paper record, and of course, tabulation is done electronically, but there's some checks and balances. We continue to build on that, and so that's really what this is about. It's about strengthening the physical security and oversight of election equipment in Texas, making sure access is controlled, tracked, and documented to safeguard the integrity of our voting process. Requires maintenance, requires equipment used in the operation of voting equipment must be stored in a locked room to restrict access. Requires the inventory of electronic information, storage media, technical details about the polling location where that media will be used. The general custodian of electronic election records is required to place security seals on each unit of voting system equipment to prevent unauthorized access. And a procedure's got to be established to document the specific seals placed on each unit, any instances where the seals are removed, including the identity of the individual removing them and the purpose for accessing the equipment. This is another layer, an important layer of security to make sure the elections are as safe as they can possibly be, and so that we can all be more confident in the results. And I'll yield.
Thank you, Mr. Chairman. Members, any questions? Senator Hall, you're recognized.
Thank you very much. Thank you for this bill. I think it's very much needed. One comment on the issue that you brought up, where we moved away from electronic voting and where we're now requiring paper. I will point out that not all of the manufacturers implemented it the way we had intended for it to be implemented, and that was that there would be the vote and the paper could be accurately reconciled, and they use barcodes or QR codes to actually encode and transmit to the machines, which was not the intent of what we had.
That's right.
What we'd intended, and I'm not sure if we might be able to correct that with the Secretary of State's office, or if we may need to do something in law to prevent that, to get back to what we intended, and that is a legitimate paper ballot in which what you're reading on that paper ballot is what is read by the machine when it's recording it. which would fulfill the intent of it.
Senator, that's right. So that when the voter prints that ballot or marks that ballot and looks at it and sees the choices they made, what the voter's looking at, which then goes in to be counted, that's what's being counted. Is that what we're talking about, to make sure we're looking at the same thing?
That what the names, that
Yes,
there was a true interpretation off of what was printed in terms of who they had voted for, not an interpretation that's put into a QR code or a barcode.
Senator, that's exactly right. And I was, and what you said about the Secretary of State, that's a great point. As you know, we've passed bills along those lines, and the intent's been frustrated by some of those manufacturers. I believe the President's new executive order addresses that, and we should follow up with the Secretary of State. I believe they have the authority now to implement that. Let's make sure. Okay. Thank you for flagging that. It's a huge issue.
You can do that after, with the testimony or whenever. Okay.
Thank you, Senator.
Thank you, Senator Hall. Any other questions? If not, the chair opens public testimony and calls Ed Johnson for Senate Bill 2216. Welcome back, Mr. Johnson.
Yes.
And if you would state your name for the record and give us your testimony, please.
Ed Johnson, and also with the Harris County Ballot Security. Love the bill. It's good to keep all the election equipment secure. You know, it says in here that there should be a procedure for, you know, if you have to unseal the equipment. I will tell you, before each election, you probably would have to unseal the equipment 2 times. You're going to have a code check. A lot of times the software vendor has to do, you know, some kind of update to it. And then you want to do maintenance to the equipment to make sure that it's clean and ready to go. So we'll just need to, I think the bill is fine for that, but need to make sure to keep in mind that these pieces of equipment do need to be unsealed to do maintenance and code updates on. But they should be able to just reseal them again afterwards. So I think the bill would work good, and it'd be a good security check to make sure no one's tampering with anything.
Thank you, Mr. Johnson. Members, any questions for our witness? Appreciate you being here. Oh, Senator Parker, you're recognized.
Thank you, Madam Chair. Ed, as always, appreciate all the time and talent that you bring to this discussion, so thank you. Certainly concur. I remember, it takes me back to the last election. Senator Hall and I were in Dallas Central Count, very concerned with all these sealing issues. Do you think that what the bill prescribes with regard to knowing who it is, the trail that's there, is that sufficient from your perspective? That would be obviously official personnel that would be checking,
Yes.
you know, based on the software update, checking to make sure, as you said, the equipment is in functioning condition.
So software updates, you'll probably have a vendor from, in large counties, you're going to have a vendor from the software company that's going to be there. But you should be able to keep track of who that is. I mean, they usually come in for a week and do all the equipment and leave, or they will leave the update patch with either a county employee. So it's either the software vendor that they have a contract with or a county employee that's doing this work. So I think that what's there is plenty adequate for a chain of custody.
But just make certain there's adequate paper trail on those, on the
Yes.
employee personnel.
I think the bill did a good job of that.
Very good. Thank you.
Thank you, Senator Parker. Thank you, Mr. Johnson. Appreciate it. Any other
Thank you.
questions? All right. If not, is there anyone else wishing to testify on, for, or against Senate Bill 2216? Senator Hall, you're recognized.
We got a resource from the Secretary of State's office. You want to call him up to just address those
Sure,
questions?
of course.
Okay.
Christina Atkins with the Secretary of State is here as a resource witness. Thanks for being here. You've been summoned. Thank you. And why don't you go in and introduce yourself, and then we'll take a question.
Good morning. My name is Christina Adkins. I'm the Director of Elections for the Texas Secretary of State's office, available to answer any questions.
Thank you. Senator Hall, you're
Okay.
recognized.
Thank you for being here. The question is, that you heard we talked about, is that we have some of the machines that don't read what the people read on the ballot. The intent when we went to a paper ballot was for people to be able to have confidence that what they read on the ballot was actually what was being counted with the machines. And we do have machines that transfer the vote through a barcode or a QR code in some way or another. Is that an acceptable, are we continuing to have that, or do we need to do something to correct that?
That's a great question, Senator. So you mentioned earlier the executive order that was issued that speaks to this particular issue. That executive order is a mandate to the Election Assistance Commission to modify their voting system standards to address that particular issue. Our state certification process, we require federal certification before a vendor can even come to the state, and we require that federal certification in order to stay certified. So right now we are working with the Election Assistance Commission. We're waiting to see what actions and what their timelines are for updating their standards before we address any issues with our state standards and whether we determine if somebody needs to come back in for recertification. We need to see what they're doing and what their timelines are because that impacts the next steps for the state.
Okay, I understand we have to stay in line with them, but let's say they drag their feet or they don't come back with an answer or whatever answer dodges the question that was asked, where we still have the situation in Texas that we've had before. Do we need to take some action in the legislature to fix that, or is it within your purview to be able to do it?
Well, right now, our state law requires federal certification. And so I think that if we need to have some discussions about whether we need to stay aligned with that federal certification process or be able to create some policies in Texas that are distinct and different from what the federal policies are with respect to federal certification, those are some conversations we probably need to have, and I'd be happy to follow up with you, Senator, to see if there's any action that needs to be taken legislatively.
Okay, and one other question if I had, that had to do, a statement was made earlier with regard to electronic poll books and countywide voting and ballot secrecy. Can we continue going forward with the same equipment that we've been using and maintain ballot secrecy with countywide voting? Or is the only solution we have for that is the redaction solution?
Another good question, and another one that has a little bit of a complicated answer. I think when we're talking about ballot privacy and ballot security, which is absolutely critical to the success of our elections, is protecting an individual's constitutional right to a secret ballot. When we are trying to solve the issue to maintain that, or rather when we're trying to solve that question, we're trying to answer the question with respect to ballot privacy. There is no one solution to fixing that. And I know a lot of individuals have brought up the idea of countywide being part of the problem. On that issue, there may be some concerns there, but by and large, the issue on ballot privacy, it's impacted by the early voting process, by early voting by mail. And so I think whatever solutions we put in place to address ballot privacy, we have to understand that we have to incorporate many different aspects of the election process. Election day, early voting by mail. I think anytime we have a situation where we have categories of voters where it's a small category in a certain, or a small number of voters in a certain category, that's where we're having problems. And so identifying those different areas and looking at this kind of holistically.
But it is something we need to do because currently we do not have assured ballot secrecy with the system we're currently using.
Yes, sir. There have been documented reports. I think many folks are familiar with the articles that have been published that have identified this problem, through publicly available records. There are certain circumstances in which you could identify an individual voter's ballot. And so definitely looking at that situation and looking at I think there's several different aspects that need to be addressed in order to address that particular problem.
Okay, thank you. Yes, Mr. Chairman, now this is a serious problem that we can't allow this session go by without fixing it. We've known about it too long, and there are some conveniences to election that we may have to change or may have to give up. But I think at the top of the list of what we have to consider is the right of the individual, all individuals, to the secrecy of their ballot. And if we have to give up some convenience in the election process to do that, I think it's incumbent upon us and our responsibility to the public that we do that. Thank you very much.
Yes, sir. Thank you, Senator Hall. Thank you, Ms. Atkin. Thank you. Appreciate you being here. Members, any other questions? Senator Parker, did you have a question?
I was just
for
going to
resource
comment
officer?
really basically on what Senator Hall said. Senator Hall, I agree with you completely. I think that issue has to be resolved. And so, whether or not we do it here or after the fact in the discussion, but we need to have a plan to address this topic. So let's circle back on that maybe later today.
Be glad to talk to you about my plan.
Let's do it.
Thank you.
All right. Thank you, Senator Parker. Thank you, Senator Hall. Appreciate you bringing that up. Incredibly important constitutional right that we're protecting. All right. I think that is all of the witnesses we have registered. Is there anyone else wishing to testify on, for, or against Senate Bill 2216? Seeing none, public testimony is now closed and the bill will be left pending. That's it.
Very well. We thank, that concludes our posted agenda. We thank each member of the committee and their staffs, our excellent committee staff, all the witnesses for and against the bills, our resource witnesses, and all the folks at the Senate that work so hard to keep things moving and documented and broadcast and running smoothly. And so if there's no other business to come before the Committee on State Affairs stands in recess subject to the call of the chair. Good morning.